everybody in there? I'm going on the record.
Yeah.
Yes, ma'am.
Something to move.
Just real quick.
No problem.
You just stand too.
Mr. Bigelow, did someone send me the files? For Autumn
Ms.
Ridge?
Nash did. Did you send
We
it?
didn't do the jury trials, only that one's at 8:30.
Oh. We didn't send you the one set for jury trial. Send it to you.
I just need the ROA and my last order.
Okay, 1 second.
Okay, I see, is it Conway in the courtroom? They might have muted you because I can't hear anything.
There you go.
Okay.
Good morning, Judge.
Good morning, and you're here on the,
Kapaka Sasha versus Darnell Walker.
okay, and Darnell Walker has not appeared?
He has not.
What about Lamixia Embry?
She has not.
Okay. Ms. Nash, you're still in there?
Yes.
Okay, I'm gonna go on the record on that matter. On the record in the matter of Capricasha LLC versus Darnell Walker and Lamixia Embry, file number is 21-01461LT. Can I have your appearance, counsel?
Good morning, Judge. Emily Conway on behalf of the plaintiff, Kapaka Sasha.
Thank you. Today was the date that was scheduled for a jury trial. The matter was set for 8:15. It's currently 8:37. No one has appeared on or behalf of Darnell Walker or Lamixia Embry, the defendants. And so a default judgment can be entered. Can you prepare an order? A judgment in
Judge.
order? Okay. Any additional matters for the record?
No, thank you, Judge.
Thank you. You're all set. Okay, we're on the record in the matter of Autumn Ridge Townhomes versus Lakia Leak and all other occupants, file number 21-00861 LT. Council appearance.
Thank you, Your Honor. Christina Corcoran appearing on behalf of Ms. Leak.
Thank you. Today was the date that was set for a jury trial. We were present in the court back on March 8th. There was a motion filed on February 18th for a motion to withdraw. I gave the attorneys 2 weeks to file a new appearance of an attorney. We have representatives in the courtroom. Can you state your name, please, again, from Autumn Ridge?
My name is Letitia Bryant.
Okay.
Ricardo Colon.
Okay. And they're proceeding, and they're present without counsel. There was an order that I issued back on February 18th that they needed to file. They must file in a new attorney appearance. Autumn Ridge was required to do that because we were having a trial set for today. Why is there no attorney appearance from Autumn Ridge?
We were we just recently found an attorney and they weren't available yet, so we're just getting them set up with a retainer.
Okay. Ms. Corcoran?
Thank you, Your Honor. As Your Honor has stated, the plaintiff was ordered to obtain new counsel within 2 weeks. I would motion the court to find plaintiff in contempt of the order, or in the alternative, Your Honor, Michigan law prohibits the unauthorized practice of law, which means an officer or partner or employee cannot appear for a corporation because they are not here with counsel. I would argue that they have not appeared, and I would ask that you dismiss this matter.
Thank you. I would agree that they have not appeared. They had more than sufficient time. There was also notice that they needed to have appeared for the motion to have the other attorney withdraw. There was more than sufficient time for them. It's been over 3 weeks since my last order was entered. And they could have retained counsel and they failed to do so. And so this matter, I will grant your motion to dismiss. The matter is dismissed.
Thank you,
You
Your Honor.
can have your new attorney file a new action if that's what they intend to do, but this is a matter that's been pending. There was more than sufficient time provided to Autumn Ridge and they failed to comply with my order. So the case is dismissed. We're off the record on that matter. Now on the record in the matter of Autumn Ridge versus Nathaniel Eason, late Paris Pops, and all other occupants. File number is 21-01889 LT. Council appearance.
Thank you, Your Honor. Christina Corcoran appearing on behalf of Mr. Eason and Ms. Pops.
Thank you. Today is the date that was set for a jury trial. Again, this is a matter in which the court had a hearing back on the 14th of February. And the attorney indicated that he had not had meaningful contact with his client and that they had not provided him with enough assistance for him to be able to properly appear and represent the client's interest at trial. I ordered that he could be released from representation on that matter, but that new counsel appearance needed to be filed within 2 weeks and that the trial would not be adjourned. And here we are today without any attorney appearance. And so I'm assuming you're making the same motion, Ms. Corcoran.
That is correct, Your Honor. I would motion to dismiss the matter as this corporation has failed to appear.
Thank you. I find that the corporation has failed to appear and comply with the court order, and so the case is dismissed.
Your Honor, for record-keeping purposes, if I don't know if Ms. Nash was able to get the spelling of Mr. Ricardo's last name, if I could have that, please.
Ricardo. Last name is Colon.
Thank you so much.
You're welcome.
Thank you. And Ms. Corcoran, can you prepare an order for me on those two files?
Absolutely, Your Honor. I will do that under the 7-day rule.
Thank you. Other than that, we're all set on these matters.
Thank you,
the
Your Honor.
Thank you. Thank you to the representatives from Autumn Ridge. You're all set.
Thank you.
Mr. Bigelow, is anybody else in the courtroom?
No, ma'am, just Addie and I.
Okay. I don't see anybody here for Michael Lewis.
He has not appeared, Judge.
Okay. Okay, and Ms. Shack, you're here on behalf of McLaren, is that correct?
I am, Your Honor. Thank you. Good morning.
Good morning. Okay. On the record in the matter of McLaren Greater Lansing versus Michael Lewis, file number 14-00326 GC, counsel appearance.
Good morning, Your Honor. Millicent Scheck appearing on behalf of McLaren Greater Lansing. Your Honor, this is the date and time set for a debtor's examination.
Thank you. And Mr. Lewis has failed to appear. And so this matter was sent for 8:30. It's 8:45. It's more than sufficient time to log into Zoom or appear in person. The court will grant your request for show cause if that's what you would like to proceed with.
Yes, Your Honor, and I'll submit with the court. Appreciate the court's time today. Thank you.
Thank you. You're all set.
Thank you.
Okay, Mr. Cradaville is here. And you're here with Trayvana Alvin, is that correct?
That's correct, Your Honor.
Alvin, are you still there?
Hello?
Okay, very good. Let me call the case. On the record in the matter of RPM Auto Sales Incorporated versus Trayvana Jasmine Alvin, the file number 17-01853 GCE, counsel appearance.
Morning, Your Honor. Brent Cradaville appearing on behalf of the plaintiff, RPM Auto Sales, P75845.
Thank you. Ms. Alvin, I can't see you.
My video is messed up.
Okay, were you appearing for court today?
Correct. And the last time I called, because there's 3 options on this paper, I called, they said not to call. I explained about my phone. I'm not able to get down to the courthouse. I figured instead of missing court, I just go with the best option, which is still participate without video.
Okay, what's your date of birth?
10/27/89.
Okay. You met privately with Mr. Cradaville, correct?
Correct.
Okay, Mr. Cradaville, did you all come to any agreement?
We didn't. We discussed some things. I mean, I think it was somewhat of a productive conversation, and we discussed possible resolutions. Nothing at this time, but possibly we could in the future have a resolution. I'm not sure, but as of right now, no.
Okay. Well, today's the date set for an objection to garnishment. The objection filed by Ms. Alvin indicates that she did not receive notice the time I was able to be seen by the judge. Can you explain that, Ms. Alvin?
When they originally went to court for this, I was not served any papers. I was unaware that there was even a court date. I was not even in the state of Michigan.
Okay, so you're saying that you didn't receive the original complaint and
The original and this, the garnishment from my current job.
okay. You say you were not served the garnishment?
No,
What's
I
your
found out when I got my check.
What's your current address?
It's 1306 East Miller.
Okay, so under the court rules, ma'am, in order for you to attack or to object to a garnishment, there's very specific reasons that you can address in your objection. You cannot attack the original judgment under an objection to the garnishment, okay? Is that a yes?
Yes.
Okay. I'm trying to see here where your complaint was originally served. It looks like there was some US.
It was alternate service, Your Honor.
Okay.
That as well.
At what address was the alternate service? Or how was it performed, I should say?
It actually, I believe is at the 1306 East Miller
That's-
Road address. It was posted and sent via, let me look, let me look in the physical file. It says via mail, so it doesn't say if it's first class or
Yeah,
certified.
the address, I'm sorry to cut you off, but the address that I see on the summons to complaint is the address that she gave today. So I have no reason to believe that she would not have received service.
I was not living in this state. This is my mother's address. I was living here with my mother. I was not living in the state of Michigan from 2015 till 2017. I came back to my mother's address. This
Okay,
is my
but
mom's address. That's why the address is still the same.
Okay, so your mother was living there during the time in which service was effectuated?
You said what?
That your mother was living at that address at the time the service was made?
Yeah, my mom was living here. I'm not
Okay.
sure. I never received any papers though, and she never told me anything about any papers.
Okay, I also have a contract here that you signed back in 2015 for a motor vehicle retail installment sales contract. You gave the same address on Miller Road. Did you update them when you were no longer living there?
2015, that what?
It's a sales contract for a 2005 Chrysler Pacifica, which is the issue in this case. In that contract, you give the address that they served you at. Did you update them when you were no longer living at that address?
No, because they didn't come get the car from this address.
Okay, that was not my question. I asked you, did you update them when you were no longer living at that address? So that
They know that I was no longer living at the address, yes.
we can't speak to what they know. I can only speak to the documents that are a part of this file, and all of the documents show your address as 1306 East Miller Road, apartment 18, which is also the address that you just provided the court. But all of those things are just for me to explain just a little bit of clarity of why you were served without being present. It's because there was several attempts to serve you. You provided no other forwarding address. This was the address that you put on your contract. It's also the current address that you live at now. So it's reasonable that service was made at that address, whether your mother provided you notice of that or otherwise. The other issue is that, again, per the court rules, you've not provided a reason that I can grant your request for an objection. It has to be one of the reasons from the court rules, and not receiving notice from the complaint is not one of those reasons. You're trying to attack the judgment and not the objection.
No, Miss, I just wanted to be heard and seen. I didn't, and I wanted to come to a different term as far as the payments and the garnishment. And I wanted a chance to be able to have my words. Like, that's it. Like,
I understand.
Just,
I totally get that. But what I'm trying to explain to you is that you can't attack the garnishment this way. What you're doing is trying to attack the judgment, but you're doing it through a garnishment. And I don't have reason to grant that request. Now, it does sound like Mr. Cradavell and you can come to an agreement outside of this. And I'm happy to set this for a review date to help facilitate that, or you all should be able to do that amongst yourselves. And maybe you can come to an installment payment plan that works for you or some other agreement. And then if you do come to that agreement, then he can decide whether or not he wants to set aside the garnishment and while you are on that plan and he'll file a paperwork with the court to let us know you're on the plan, okay?
Mhm.
Is that a
Yeah.
yes? Okay. Okay, so as to your motion or your objection to the garnishment, I have to deny it, I'm sorry, because you did not provide the court with a sufficient basis to grant it. But I understand from Mr. Cradaville that you all are possibly going to be able to come to some other agreement. So would you like another date, Ms. Alvin?
No, I do not want no more court dates.
Okay, well, then you and Mr. Cradaville should have each other's contact information.
The only issue, Your Honor, is I don't have a phone number for her. I have her address, and that's about it.
Okay, well, you all can, if Ms. Alvin, did you want to go back in the private meeting room to give him your number so that you all can discuss another way for you to make payment on this or resolve this versus this objection
Yes.
to the
that's fine.
garnishment? Okay, you're already in the breakout room. You just go back to breakout room and you should see where you're in room 1. You can return to room 1. He'll return to room 1 and you can give him your number privately, okay?
Okay, thank you.
You're welcome.
Thank you, Your
Do I
Honor.
leave after this?
You're free to go after that. Thank you.
Thank you. Have a good day.
You too. Okay, Jackie Snyder, I see is here. And Daniel Best. Mr. Best, you're here for Progressive Marathon?
That is correct, Your Honor.
Okay, is anyone in the courtroom for Medard Yahweh? Okay.
There's nobody in the hallway either, Judge.
Thank you. On the record in the matter of Progressive Marathon Insurance versus Medard Yahweh, file number is 21-01641 GCE. Can I have your appearance, please?
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of Plaintiff Progressive Marathon Insurance.
Thank you. Today was the date that was set for a hearing on objection to plaintiff's motion. I'm sorry, objection to defendant's motion for installment payment, but the defendant has not appeared. Don't see where, I don't believe I signed the request for installment payment. They're requesting for payments to be reduced to $25 a month. But I don't believe that they provided any reason why they needed the payments that low. They've also not appeared today, so I'm going to deny their request.
Very good. Thank you, Your Honor.
Thank you. You're
Does
all
the
set.
court have an order, or do you want me to submit it under 7-day?
Let me see. I can just deny the request on the form they've submitted, so you're all set.
Very good. Thank you. Have a good day, Your Honor.
Same to you. Okay. I don't know why this is not uploading.
Judge, do you want me to send you this individually?
Let me see what's going on here. Miss Snyder's here for Mr. Rosberry, and then Miss Corcoran, you're on the same matter for Cedar Place Apartments.
Correct, Your Honor.
It just says hearing. Is this what's the hearing for?
Your Honor, Mr. Wasbury filed a default request as well as a request for a writ of eviction, and I filed an ex parte motion to stay, and the matter was set on for today.
Okay, sounds good. I need those. Yes, I need you to send it separately because whatever you sent me or Mr. Nash sent me is not open.
just want the order. Is that right, Judge?
No, I need the motions and the responsive motion. Let me just- Okay, we're on the record in the matter of Rose Community Management Cedar Place Apartments versus Delway Energy, file number 21-00613 LT, council appearance.
Thank you, Your Honor. Jackie Snyder Padar on behalf of Mark Bosbury, 82554 is my P number.
Thank you, Your Honor. Christina Corcoran appearing on behalf of Ms. Finnerty.
Thank you. Today was a date that was set for hearing. I have a defendant's ex parte motion to stay the writ of eviction that was filed by your office, Ms. Corcoran. And then there was a responsive filing, I believe, from Mr. Wasbury's office,
Yes, Your Honor.
indicating that this was due to a health hazard. So, Ms. Corcoran, I'll let you proceed with your motion.
Thank you, Your Honor. While I do agree with plaintiff's objection that my motion is not based in law, it is not a baseless request. Under Summary Proceedings Act, this court has equitable authority. Ms. Finnerty is a vulnerable adult. She apparently was stricken with COVID, hospitalized in the time frame from when we entered into the agreement that she would vacate. And then after her hospitalization, she was placed in a nursing facility in which she is not, she doesn't have the liberty to leave. Since finding out about her whereabouts and her health, I have diligently attempted to get any assistance that I could in order to remove her belongings. I just felt it was my due diligence to do something, to take some, make some efforts in order to try to prevent her belongings from being thrown in the garbage, which is what will happen when the writ is entered. And so then I just defer to the court.
Okay, so you're stating that she is in a facility and she's unable to leave?
That is correct, Your Honor.
Okay, so then what's the plan? I mean, the
That's,
plaintiff, I guess it couldn't be a request for the plaintiff to just lay in wait for Ms. Finnerty to have a plan.
I understand, Your Honor. Like I've done every single thing. I've reached out to every agency. I've tried every avenue that I could possibly do aside from going there myself. And I just had to do what I could try to do. And like I said, I defer to the court.
Ms. Snyder?
Your Honor, there was no reason that she couldn't contact, Mr. Wasbury's office and try to reach some agreement regarding this stuff. And as she stated, the objection of that her ex parte motion is not only not based in law, but it's also this entire process. Mr. Wasbury has been very responsive to everything that the defendants have requested. They did a consent motion for her to move. And I understand she was struck with COVID after that point, but this case has been pending for a year, Your Honor, with this health hazard still prevalent the entire time.
May I respond, Your Honor?
You may.
It sounds as though Ms. Snyder was not fully informed of the communications that I've been having with Mr. Wasbury, and he was fully informed that my client was hospitalized and that I was doing everything I could to assist her in trying to get her belongings out. We both have jobs to do. I understand he has to file this request, and I did what I had to do for my client.
Okay. And as of today's date, Ms. Corcoran, there's no plan of action in place as to where her stuff could go or who could remove her stuff to make sure it's safeguarded. Is that correct?
That is correct, Your Honor.
Okay, well, I don't see any legal basis whereby I can grant this request. It's an unfortunate situation. I mean, we're having, I believe is Ms. Finnerty elderly?
That is correct, Your Honor.
Yeah, we have an elderly woman here who I'm presuming lives by herself, which could also explain the unfortunate condition of the property. But then the other unfortunate thing is that her entire life, I'm sure, her important documents and otherwise is contained in this household. And there's no way or no one that can assist her with getting that stuff out. If Mr. Wasbury's office would be inclined to allow someone the opportunity to at least retain or retrieve her personal items such as birth certificates or memorabilia that she doesn't want to be disregarded, I will allow that opportunity so that I won't grant an immediate writ. I'll give some time so someone can go in and get those things, because some of those things may never be able to be recovered. And that's an irreparable harm that the court would not like to see take place, even in the course of this unfortunate series of events. So what I will do is I will delay the issuance of the writ for another 10 days to allow somebody to go in and get or retrieve her personal items there that she knows that she cannot recover if it's discarded of. And then I have to grant their request to issue the writ at that point, okay?
Thank you, Your Honor. I appreciate Your Honor's grace.
Thank you, Your Honor.
No problem. Can you, Ms. Snyder, can you provide Ms. Corcoran, can you provide an order under the 7-day rule?
Yes, Your Honor, I will do so.
Thank you. Any additional matters for the record?
Not at this time, Your Honor.
Nothing for defendant, Your Honor. Thank you.
Thank you. You're all set.
Thank you. Have a good day, Your Honor.
Same to you.
Thank you, Your Honor.
Thank you. Have a good one. Okay, I see Mr. Freeman for Fountain Place.
I was supposed to be here with my daughter, Lamisha Embry.
Oh, that was at 8:15.
Yeah. Okay, thank you.
Hello. Julius Aldrich Surratt.
Okay. On the record in the matter of Fountain Place Limited Partnership versus Sirius Surratt's.
Makula is on the lease with me.
I'm sorry, don't speak over me, okay? And I'll give you an opportunity to talk. And Richard McCullough, file number 21-02387 LT, council appearance.
Good morning, Christopher Asphalt, 53129 for the plaintiff.
Okay, and Mr. Rod, did you retain counsel?
I did do legal services. I retained staff attorney Christina Corcoran.
You have not retained Ms. Corcoran. She just left our courtroom right before you logged in. She's not representing you on this.
Then no, ma'am, I will have to pro se.
Okay. Well, today was the date that we adjourned this because you indicated you were going to seek counsel through your tribe. And then also the court wanted an opportunity to look into a matter that you indicated from another case. There was an eviction that was previously dismissed, but it was dismissed by stipulation of the parties. And not based on what you indicated to the court previously, was that the judge said it was ridiculous. It was stipulation by you and Mr. Asphalt or the attorney for Fountain Place to dismiss that case. And the judge just signed it. Do you recall that, ma'am?
No, ma'am.
Okay, well.
I would at that hearing.
Okay, well, you've not provided the court with any evidence to support your claim that this eviction is retaliatory. You've also not taken your opportunity to hire counsel, which you stated that you would. And you've not been able to provide the court. I'm sorry?
We did retain legal services and we signed a waiver and we both signed retainer.
Legal services is not representing you on this matter, ma'am.
Okay. I'm American Disability. I will be homeless at the end of this hearing.
Okay. I apologize, ma'am, that you are being met with these series of misfortunes. You did indicate to the court that you had alternative options as to how you could get counsel. You said that you could get counsel through your tribal benefits. You've not taken advantage of that. Legal services, I believe, did represent you in the previous matter. They're not representing you on this matter.
Yeah.
I've asked you, ma'am, to submit to the court any support that you did have to try to sustain a claim that you're making that this eviction is being done retaliatorily. You've also stated previously that you thought you shouldn't be evicted because you were seeking some SARA benefits. Again, this is not a eviction for non-payment. It's just recovery. It's for possession of the property. You've not provided the court with any legal basis to support your case. So the court is going to grant possession to the plaintiff in this matter, okay?
We asked for time to get our possessions out of here, Your Honor.
Yes, I can put you and Mr. Asphalt in a private meeting room and you all can discuss a timeline, which is always the option.
Your Honor,
I can't, but the court, I can't give you a timeline other than what the court rules allow me.
Well, we're gonna be homeless. I did everything I was told possibly I could do. I did apply for tribal housing. It's not in this radius of Lansing. I have to relocate. I will statute of limitations. I will be appealing this decision. And we just have for time to get our possessions and our bodies safely out of this condemned building.
Your Honor.
Let me just respond to her.
Okay.
Just briefly. Ma'am, you absolutely can, you have the right to appeal this decision if you would like. If you believe the property is condemned, you probably shouldn't be staying there And that if the property is condemned, that might be why they need possession. But nonetheless, Mr. Asphalt, you wanted to make a statement.
Yes, as the court knows, there's a 10-day statutory period that she's entitled to. My client's been waiting a long time for the property, but in an effort to try and help as much as they can, I am authorized to give them an additional 10 days, Judge.
Okay.
So I would request that we just submit a judgment, and it will be 10 days beyond the 10-day statutory period.
Okay, so a judgment will enter in favor of the plaintiff, and ma'am will grant you 20 days, which is 10 days in excess of the statutory amount for you to remove your items from the property. You're muted, so if you're addressing the court, I can't hear you. Okay, well, she has terminated her portion of the hearing. Can you prepare the paperwork, Mr. Asphalt?
I will, Your Honor. Do you want to confirm the exact date you want to use? Do you have a calendar in front of you?
Yes, give me just a moment. I have 10, oh, you said 20 days, I'm sorry. Okay, it looks like she's rejoining.
Ruined our credit. I mean, just ruined our credit here in Lansing, my residency, everything.
Okay, I have March 30th, Mr. Asphalt.
Very good, Judge. I will submit the order later this morning. Thank you. Have a good day.
Thank you. You're all set. Okay, Mr. Best.
Good morning again, Your Honor.
Good morning. Which matter were you appearing on?
Well, we had the Progressive Marathon versus Yawa. I got an email from your clerk asking me to log back in, indicating that the defendant is now present.
He's here in the courtroom, Judge.
Oh, I was not made aware of that. That's Mr. Yawa with the red on?
Yes, ma'am. He just arrived.
Okay. You can come up to the table. Mr. Rott, you're free to go. Okay, we're on the record in the matter of Progressive Marathon Insurance versus Medard Yawa. File number 21-01641 GCE. Can I have your appearance, counsel?
Thank you again, Your Honor. Daniel Best, P58501, on behalf of Plaintiff Progressive Marathon Insurance Company.
Thank you, Mr. Yawa. Do you have, is it Yawa or Yawa?
Yawa.
Yawa. Mr. Yawa, do you have an attorney?
No, yeah.
Okay, today was the date that was set for a hearing because Mr. Yawa, you filed an objection. I'm sorry, you filed a request to reduce your installment payments to $25 a month. And the plaintiff has filed an objection to that request, indicating that you owe $7,376, accruing interest at 2.04% from the date of judgment, and they want you to pay at least $200. Okay, I see here. Are you currently employed, sir?
Yes, Your Honor.
Okay, in your paperwork that you submitted to the court, you indicate that your average income is about $1,200 a month.
That's correct, Your Honor.
But then you also indicate that you pay $800 in your rent mortgage and $300 in utilities, and then it looks like $350 in child support. That's more than $1,200.
Yes, Your Honor. I get help from family and friends sometimes, unless I put in a little bit of overtime.
Okay. Do you have any check stubs to support this?
No, not with me, Your Honor.
Where are you employed?
Garrison, it's a smoke shop.
You currently have a 2015 Ford Explorer?
Yes, Your Honor.
Okay, Mr. Best, did you want to say something?
Yeah, I'm sorry, I did not catch the employer was muffled. I heard air or something.
Garrison, it's spelled Guirison.
Thank you.
Okay, Mr. Yewa, if your family can help you with these other bills, including, I'm assuming, this nice truck that you're driving, because you didn't include that in your rent and utilities that you stated here, then why can't they help you pay this debt that you owe so you can have good credit?
Your Honor, the truck was necessary. I had to have that truck to go back and forth to work because I have sole custody of my two sons. So instead of just staying home and not being afford to pay the bills, I needed a truck to go to work. That's why
I recognize, I don't dispute that you need reliable transportation, but your statement is that the truck was necessary. Why wouldn't paying your debts be necessary?
I pay my debt is necessary. I'm not saying I don't want to pay it. I'm just saying what I can afford at the time.
Okay, well, you got a $20,000 vehicle. You can, based on what you're stating here, you can't afford that.
You said what now?
You have a $20,000 vehicle and you're saying that you only bring in $1,200 a month and $800 of it goes to your rent. $300 of it goes to your utilities, which includes water, electricity, and gas. Yeah. So you can't afford the truck either.
Yeah, I know the vehicle was acquired before the judgment was put in or whatever. So I didn't even know I had to owe $7,000 before I got the vehicle.
Okay, look, $25 a month, they'll never get their money. We'll all be gone and passed away before they get their $7,000 if you think you're going to pay $25 a month. So you need to figure something else out. What I can do is put you in a private meeting room and get you on Zoom. You can meet with Mr. Best and he maybe can ask some additional questions about your financial status that maybe you don't want to disclose to the court, and then maybe come up with another agreement. If not, I'll make a decision, but it's not going to be $25 a month when you drive a $20,000 vehicle.
Okay. I can't tell you what I can pay and I don't have it to pay. And then
right, you don't, well, you told me that your family would help you. So have your family help you pay this.
I could ask them. I'm not putting that, if I could ask them.
You're obviously asking them to help you pay this other stuff. You literally put here that you bring in $1,200, and then you indicated here that you're putting out more than $1,200 a month But you didn't even include the car payment in here. You didn't include food in here. You didn't include clothing or anything else. So you must be getting a whole lot of help. Or
Yes,
you're not
I
telling,
get food
or
stamps.
you're not telling me what you're bringing in. And
I get
so,
food stamps from the government, Your Honor.
okay, but still, there's still other, you don't eat out ever?
No, I don't eat out. I can't
Okay.
afford it.
You put gas in your car?
Yes, Your Honor.
Okay, and you didn't include all of those things in this accounting that you put here for the court. You say you put $800 in rent and mortgage, 300 in utilities, and that doesn't include a cell phone, doesn't include cable television, none of these things. So you must have some other money somewhere, or other access to money. That's just evident by what you put here, that you have access to some money that you're not disclosing to the court, because you are able to get or pay for your $20,000 vehicle, and you didn't include that here. None of this is included here in the 800, 300, or 350. So you must have some resources somewhere. So then there's no reason for the court to believe you can't find the resources to pay this debt.
Yeah, I don't have no other resources. I mean, with the internet, the government is paying for the internet. And I don't have no cable TV. And
Who's paying for the car note?
I'm paying for the car note.
You didn't indicate that here. How much is your car note?
$558.
Okay, you're bringing in more than $1,200 a month.
No.
Not with rent being $800 and a $500 plus car note. That's more than 1,200 right there. That didn't include the 300 that you say you pay for utilities. It doesn't include the 350 that you say you have in court ordered child support, which you put twice. So I don't know if that's because you have 2 children or if that was an error when you completed the paperwork. But you got some more money somewhere, sir. So what I'm gonna do is put you in a private meeting room so that maybe you'll be more forthcoming with Mr. Best than you're being with the court about how much money or access to money you have. And maybe you can come up with a better agreement about repayment. I'm not granting the request for $25. So you might want to figure something else out.
Mr. Best, were you able to talk to Mr. Uoff?
Yes, we have an agreement provided it's acceptable to the court.
Okay, thank you. Just a moment.
Okay, we're back on the record. The parties met privately. Did you come to an agreement about a new amount for the payment plan?
We did, Your Honor. Although the defendant was not forthcoming on income, he has identified that he is in the process of obtaining child support assistance, which once he has his child support in place, he expects to be able to work more hours and increase his income. Based on that, we are agreeing to a monthly payment now of $75 per month. The first payment will be due March 20th, 2021. I've advised the defendant to mail that payment to my offices with the caveat that in 1 year, this amount will be reviewed for increase based on his hopefully then increased income.
Okay, very good. Okay, and that's what you agreed to, Mr. Yewa?
Yes, Your Honor.
Okay. Okay, so, and you said the first payment is going to be March 20th?
That is correct.
Okay, 2022, and then you'll review, or we'll review, set it for review 1 year out to see his financial status at that point.
Yes.
Okay, so that will be the order of the court. Mr. Best, can you prepare an order under the 7-day rule?
I will do so. Does the court want me to set a hearing date now, 1 year out?
Yeah, we're gonna give you a review date now.
Okay.
It won't let me schedule anything out.
So what?
It won't let me schedule anything out that far.
Judge, it doesn't appear that it's going to let us schedule something in the civil calendar that far out right now.
How far out is it letting you go?
How far out?
Till the end of December.
She says till the end of December.
Okay, we'll follow up with the civil department. We'll have them set it and they'll mail notices.
Very good.
Okay, thank you. Any additional matters for the record?
No, Your Honor.
Questions, Mr. Yewa?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you. Have a good day, everyone.
You too.